The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon and welcome to council and to all of those watching through our Supreme Court Live channel. We look forward to arguments in this afternoon's case. Mr. Shima, I would ask you to please read the 1:30 docket.
Thank you, Your Honor. May it please the court. 3 p.m. docket for Wednesday, December 16th, 2020 consists of one case. Appeal number 120033, in re estate of Thelma J. Taylor, Atchison County, briefs both sides. The appellee petitioner has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Patrick Henderson of Atchison appears on behalf of the Boys and Girls Club of Atchison, Kansas.
May it please the court, the appellant Laura Kelly, administratrix of the estate of Thelma J. Taylor, appears by counsel John W. Fresh.
Thank you, counsel. We have read your briefs and look forward to your argument. Mr. Henderson, you may begin.
Thelma Taylor resided at Mall Towers, which is a high-rise apartment building in the city of Atchison. She was acquainted with Laura Kelly, not our governor, and who was also known as Laura Pennington, who was a receptionist for the apartment building. In August of 2015, Thelma added Laura as a joint tenant on her checking account, added her to a safety deposit box contract at a local bank, and placed her Kia Optima automobile into joint tenancy with Laura. A few days later, Thelma executed her last will and testament. And less than 3 months after that, on November 18th, 2015, Thelma died. In the days following Thelma's death, Laura sold, gave away, and otherwise disposed of Thelma's personal property. Not a single record was kept of what property was sold or of what was received for it. On December 2nd, 2015, Laura entered the safety deposit box at the bank and discovered that the box contained over $11,000 cash, which Laura removed and deposited into the joint tenancy account that had previously been established by Thelma. 2 months later, on February 17th, 2016, Laura offered the last will and testament for probate. The residuary beneficiary and the only beneficiary mentioned in the last will and testament is the Boys and Girls Club of Atchison, Kansas. And while her initial inventory and valuation neglected to mention the cash from the safety deposit box, Laura eventually disclosed it, although she then claimed to be a co-owner of the funds through joint tenancy. In June of 2017, she filed a petition for final settlement, paying herself and her attorney a funeral bill and some other items, leaving a balance of less than $500 to be given to the Boys and Girls Club. The Boys and Girls Club objected, asking for an accounting because one had never been given, and for the imposition of the penalties mentioned in KSA 59-1704 due to Ms. Kelly's conversion of the cash. At the trial court level, Laura Kelly argued that because the safety deposit box was jointly held, so was the contents of the safety deposit box. The trial court made clear that in order to establish ownership of the cash, she would have to show that there had been an inter vivos gift of the cash, following black letter principles of an intention to make a gift, delivery, and acceptance. The trial court found that Laura had failed to show that there had been any gift, and that factual finding is well supported in the record. But as a result of that, the court found that Laura had wrongfully converted the cash. The court therefore ordered her to pay back the $11,000 plus damages of $11,000 under KSA 59-1704. A 2-1 decision of the Kansas Court of Appeals followed the dicta from prior Court of Appeals cases and found that the penalty provision should not apply to Laura because she had not yet been appointed as fiduciary at the time she converted the cash. That sort of slavish reading of dicta is misplaced. In statutory interpretation, the first things courts always look at is the plain meaning or plain language of a statute. That is, the first step should always be to read the statute. KSA 59-1704 is a short one. It provides, if any person embezzled or converts to his or her own use any of the personal property of a decedent or conservatee, such person shall be liable for double the value of the property so embezzled or converted. In order to reach any of the other canons of statutory interpretation, there has to be some ambiguity. None is apparent here. The alleged ambiguity is created only because of that dicta in prior appellate cases. In its decision, the Kansas Court of Appeals in this case addressed the legislative history of KSA 59-1704 and mentioned the prior case of In re Trusteeship of McDonald, a 1991 case. In McDonald, the settlor of a testamentary trust died testate. The property was probated and thereafter the estate was closed. The trustee later wrote 2 checks to a beneficiary, giving one to the beneficiary, but depositing the other into his own account. When questioned in later trust administration proceedings, he returned the money to the beneficiary. The trial court declined to impose the double penalty for conversion under 59-1704. The court found that McDonald's estate and the trust corpus were distinct, and the court declined to expand the meaning of what it called a penal statute. In essence, the court held that the trusteeship check was not personal property of a decedent. The court also went into, in McDonald, the court also went into the legislative history of the statute. The original statute, which was part of general statutes from 1935, and actually before that, from the 1923 version that I have, applied only to an executor or administrator. The amendment, if you will, or the replacing statute in 1939 applied to any person. And applying that reasoning from the Court of Appeals, the 1939 amendment is effectively restricted to only add conservators upon those to those upon whom double liability may be imposed. And the idea that the legislature meant to say executors, administrators, and conservators when it said any person is simply difficult to accept. Further, the court in McDonald explained what it meant by strict construction of a statute. Quoting from a prior case, the court said, quote, the rule of strict construction simply means that ordinary words are to be given their ordinary meaning. Such a statute should not be read so as to add that which is not readily found therein, or to read out what, as a matter of ordinary English language, is in it, end quote. The court then applied those same principles to 59-1704, declining to include trust funds within the statutory language which explicitly referred to personal property of a decedent. That is, McDonald addressed the second part, the personal property of a decedent, and did not address the first part of any person. A point missed by the court in Bolton is a quote from McDonald that says, quote, plainly, Charles is any person, ... I agree that Charles was in that category of any person and that as such would be subject to the penalties under 59-1704. Using the Court of Appeals reasoning, however, he likely wasn't in any person, according to the court in this case. Furthermore, the idea that Laura's liability for the penalty is based upon when she converted the funds does not seem to fit within the plain language of the statute. The Boys and Girls Club also submits that following that dicta in Bolton is simply bad policy. And there are several examples mentioned in the petition for review. Imagine a burglar who looks through the obituaries to find out when a decedent's funeral will be held, and then breaks into the decedent's house and burglarizes it during the time of the funeral. There's nothing under that statute that would seem to shield that person from liability simply because the person had not been appointed as administrator of the estate. Imagine a scuba diver who is hired to retrieve a drowned corpse from a lake. And if that scuba diver removes the decedent's diamond ring before bringing the bottom to the surface, that diver has clearly converted the personal property of a decedent. There's no rational or policy justification for freeing that person from double liability under 59-1704 simply because the scuba diver had not been appointed administrator of the decedent's estate. The same with an undertaker who removes cash from the pocket of a decedent. Or a nurse.
Did I hear you correctly that you believe that a burglar who is finds in the paper that the person is deceased and then breaks into that home would be liable under this statute?
Absolutely. The person should be. That person is clearly any person. And if what they steal is personal property of a decedent, that person should be held liable.
It goes that far. Any person goes that far. There's no limitation.
Yes.
Okay.
Absolutely. I believe it does. And that's what the statute says. The legislature was smart enough to say any court-appointed fiduciary who converts is liable for the penalty, and they didn't say that.
Counsel, does Bolton really not really address, or is there an argument to be made that it doesn't really address the any person argument? It really dealt more with whether or not the conversion affected personal property of a conservatee, and because the appointments had not been made at that time, the conversion didn't affect the personal property of a conservatee. And if we were going to apply that here, the question really, the only way Bolton's applicable is whether or not the property was converted at the time or post-death, whether there was a conversion from a decedent. Is that how we read Bolton?
Well, I agree with what you're saying. And yes, that's how I would interpret it. But the language in Bolton goes a little further than that, but it doesn't need to reach the decision. The property that was converted was not under the control of a conservator. And thus the property was not the personal property of a conservatee, the property that was converted. And that's the same with all of the cases. Using the plain language of the statute, it doesn't change the result of any of those prior cases with the exception of this one. I see I'm out of time.
Okay. Are there any other questions? Thank you, Mr. Henderson. Mr. Fresh?
Thank you, Your Honor. May it please the court. Really, I think what we're here for today, what the petition for review really is asking you to do is overturn Bolton, which has been good law for almost 30 years. What council refers to as dicta in Bolton really is not dicta. It is part of the holding, which says, which was quoted in the appeals panel decision, where they say, where the Bolton court said, the involved individual is not an appointee of the district court, and the assets in question are not under the control of a court-appointed conservator, executor, or administrator. That's really what the argument is, and that was the basis of the Court of Appeals panel in reversing the district court, and that's the argument that the district court, I think, missed and was properly reversed by the appeals panel. Because that's what Bolton says, and that's what it said for almost 30 years. Now, I would note, and you probably all know this, the Supreme Court had the opportunity to review Bolton in 1994, and they declined to do so. So now we're bringing it back around, or they're bringing it back around. The
Counsel, let's just start with, I mean, we've never been shy about disagreeing with Court of Appeals opinions, and that's what Bolton is. Just make a plain language argument. I mean, don't you have to concede that the plain language of the statute means you lose?
I believe I do, Your Honor, I do.
So we apply the plain language of the statute.
I'm sorry, did you ask, should you apply the plain language of the statute?
Why should we not just apply the plain language of the statute?
Because I think we have almost 30 years of precedent under Bolton that has construed the statute more strictly than that. I think that's one issue. I think the other issue is it is a penal, the statute is penal in nature, and I think it has to be strictly construed. And so, again, I think the holding in Bolton is still good law. I think that the fact that this is statute is within the probate code, it requires some connection to a probate proceeding to be applicable. I think the examples, again, counsel says that to follow Bolton or to continue to follow Bolton in this circumstance would be bad policy. I think the question he was asked about the examples he was giving of a burglar or whatever, I think to expand the application of the statute that widely would be bad policy, because you have criminal statutes that could apply. I don't know how you would apply this statute if someone broke into a house after somebody passed away and stole something. To impose this statute, I think you'd have to sue them. I don't know what other vehicle you would have. And so outside of already being involved in a probate proceeding, I don't see how you can apply the penal nature of the statute. And if the actions, as the Bolton court points out, if the actions took place outside of a court administered proceeding, the statute doesn't apply. Now, the criminal statute.
Let me understand that. I'm sorry to interrupt, but let me understand that. I mean, as I read the statute, doesn't it really just create for the estate a claim against a person? I mean, so I don't see why it wouldn't have an ability to apply outside of the players of a probate proceeding, number one. And number two, this statute was amended in 1939 specifically to take out executor or administrator and replace it with the term any person. And it's almost like you want to say that amendment doesn't count. And we don't normally do that.
The Court of Appeals in 1991 in Bolton apparently said that amendment didn't count. All right. With all due respect to them and to you, that's the way I read Bolton, that part of the decision that I just quoted earlier, they read that limitation into the statute.
Well,
And
what would be wrong with overturning Bolton? I mean, it's not like a real estate provision or something that people would have relied on. It's simply defining the nature of an estate claim and giving, meaning to the plain language of the statute, which we normally do.
well, and to go back to one of my earlier points to answer that, Your Honor, the issue there would be, in this circumstance, in our present case, the circumstance is that you have the administrator of the estate who is, has done these actions. And so that's pretty easy for the court to deal with that in the probate proceeding. But if you did have another person who was not the administrator, who was just any person, again, maybe counsel's burglar example, the probate proceeding would need to bring that person before the court. So again, they would have to file a civil action against that person to seek the penalty. And I don't know, consolidate that to the probate case or file that in the name of the probate estate. I think it becomes overly complicated if you expand it out to just anybody who's not connected to the estate. And you're not connected to the estate until the estate is open, in your point.
I would like to back up a step and ask what I think is a preliminary question, which is, does the doctrine of stare decisis even apply here?
Well, Your Honor, this court certainly has the authority to reverse the lower court. So,
right. It strikes me that all of your arguments are premised in some fashion on stare decisis. But this question is a question of first impression in this court. And it sounded like you conceded that as a matter of first impression, you can't win.
I think, again, strictly reading the statute, Your Honor, any person is any person. The statute is.
So then that goes back to my initial question, which is, do we even apply the deferential doctrines of stare decisis to a court of appeals opinion?
I think the fact that it's been law for almost 30 years should certainly carry some weight, but I would certainly agree you have authority to overturn.
Well, that's not my question is not our authority. It's how we exercise that authority. And the doctrines of stare decisis are very important because they are at least supposed to constrain a court from overruling decisions, prior decisions of that court. Let me follow up with, do you know of any case in which the Kansas Supreme Court has undertaken a stare decisis type of analysis of a prior court of appeals precedent?
Not that I can name, Your Honor. Not that I can name. I think, but the other issue besides deference, I guess, to the Court of Appeals, to the Bolton decision, would be, again, just the whole policy thing. Because, again, if you expand the scope of that statute, I think the Bolton decision carries some logic to it because it applies to assets in question under the control of a court-appointed conservator, executor, or administrator. And again, I think if you go outside of that, then where do you stop applying that statute? And I just think to expand a penal statute like that in that context, it just creates all sort of, again, how do you bring these other bad actors into the purview of the probate court, or do you file more lawsuits, or what do you do? Because there are other remedies. There are criminal statutes there would be other civil proceedings you could pursue. Had, for example, in this case, had an estate never been opened, had the administrator simply said, well, I've picked up all the joint tenancy property and given away all the odds and ends, and there's really nothing to do, and never offered the will for probate, then what? Then how is this statute triggered if there was some misconduct by that person? So, and who would have standing to bring it? So I think it has to be read in the context of where it is, which is in the probate.
Counsel, isn't it true that you don't have a conservatee without a court order?
Absolutely, Your Honor, certainly.
But you can have a decedent without a court order.
I would agree. But you don't necessarily have someone to act or protect the rights or to pursue remedies on behalf of the decedent or heirs, beneficiaries, whatever that decedent, without a court proceeding. If the person's deceased, they obviously can't come back and say, hey, somebody converted my property. So you have to have some vehicle, someone with standing to drive that vehicle to pursue remedies under the statute. So it's logically within the probate code, which would logically mean that you had to have a probate proceeding, as the quote from the Bolton case I keep reading refers to. Unless I can answer any other questions, I don't believe I have anything else to offer. I do think Bolton was correctly decided. I do think the appeal, that portion of the appeal in this case, was correctly decided. I thank you for your time and the opportunity today.
Thank you, Mr. Fresh. Mr. Henderson, you're reserved 3 minutes.
I apologize for that. I also think Bolton was correctly decided. The decision in the case is, my quarrel with the decision in the case involves dicta that doesn't apply. Really, it wasn't necessary to reach the decision. The property that was taken was not the personal property of a conservatee. So it's just really the sloppiness of the other statements that are made there that I have an issue with. In this case, Laura Kelly had possession of the will. She had this sale. She didn't have any authority to do that, and the court found that. She very well might have never filed anything, and the Boys and Girls Club would never have known that they were supposed to receive something here. I think it was probably life insurance and getting the funeral paid for that required the filing of this. But surely she had some fiduciary obligation as the holder of the person having possession of the will and knowing what it said to not steal everything. And I can't see that there's anything that's a bad policy in imposing that penalty provision upon her. There's a question asked about stare decisis, and my understanding is that, strictly speaking, stare decisis would not apply because it doesn't apply to a superior court upholding a ruling from an inferior court. It only applies to a court staying with the decisions that that court has previously made. So I don't believe stare decisis is a consideration, and I also don't think this is an extremely significant case. That is, that Bolton is an extremely significant case that would change how everyone viewed guardianships and conservatorships and whether or not a person was able to steal from a conservatee.
Counsel, let me ask you a fact question to make sure I'm clear. The double penalty that the district court ordered was based only on the $11,000 in cash that was in the safe deposit box and not anything to do with the earlier disposing of the property, the personal property and household items and that kind of thing that you mentioned earlier, right?
Yes, that's correct.
Is there a reason why the district court didn't reach back to that other property?
We asked him to, but I understand the court's decision. I think it had a lot to do with not being able to tell exactly what had been sold and what it had been sold for, lack of records, which also caused a problem for us of being able to prove what had been taken.
Any other questions? Mr. Henderson, do you want to wrap up or have you?
Oh, I'm out of time. This was not nearly as painful as I thought it was going to be. So thank you.
All right. Thank you to both counsel for your arguments today. We will take this appeal under advisement. Court is now in recess until 9 a.m. tomorrow morning.